Hi there, everyone. Thank you for watching my presentation today. I'm excited to share all my research with you. Specifically, I'm going to be talking about artificial insemination in the changing world. So looking at it throughout history, the different uses, and then the social and legal impacts. So fertility services and assisted reproductive technologies, or ART, are more common in the US than ever before. The CDC estimates that around 11.3% of women between the ages of 15 and 44 have used some sort of fertility service. For example, in 2013, doctors performed a total of 191,000 cycles of ART at nearly 500 clinics across the US. And this resulted in around 68,000 babies. Now, I wanted to give kind of an overview of the different types of assisted reproductive technologies because assisted reproductive technology is often used as an umbrella term for all fertility services, but according to the CDC, ART does not include artificial insemination because ART includes only fertility treatments in which either eggs or embryos are handled. And with artificial insemination, only the sperm are handled. So this would not fall under the CDC's definition of ART. What would fall under the definition is in vitro fertilization, or IVF, which we talked about a little bit at the beginning of the semester, which is a medical procedure where mature egg cells are removed from a woman's body, fertilized outside of the body, and then they are put back into the uterus for normal gestation. Now, in vitro fertilization is normally kind of a last resort as far as fertility services go. So often people try artificial insemination first because in vitro fertilization is so expensive. Now, there are multiple different types of artificial insemination. There's intravaginal insemination with IVI, intracervical insemination, ICI, and intrauterine insemination, IUI. Now, IVI or ICI can be performed at home, but IUI has to be done under medical supervision or at an OBGYN office or a fertility clinic, because this approach involves placing concentrated sperm directly into the uterus, so it's a much more involved procedure. So artificial insemination was originally developed to help couples conceive in cases of severe male infertility of either a physical or psychological nature. The rationale behind artificial insemination is to increase the gamete density at the site of fertilization. And it's most often used when a male is sterile or impotent, or when a couple just suffers from unexplained fertility. Now, donor insemination is most commonly used by women that have no male partner, so either lesbians or single women looking to conceive. I wanted to give a brief overview of the history of artificial insemination because I found it to be a fascinating history. According to unofficial history, so urban legend, the first attempts to artificially inseminate a woman were done by Henry IX of Castile, nicknamed the Impotent. In 1455, he married Princess Joanna. After 6 years of marriage, she gave birth to a child. And throughout this rumoring, the 6 years, they thought that he was impotent. And when she suddenly gave birth to a daughter, many contemporary historians assumed that artificial insemination had happened. But the first recorded successful experiment with artificial insemination did not happen until 1780, when Lazzaro Spallanzani developed a technique for artificial insemination in dogs. And then later in the late 1700s, John Hunter performed the first recorded experiment with artificial insemination in humans. So the first physician to take a systematic kind of experimental approach to artificial insemination was the 19th century surgeon J. Marion Sims. Sims is known for founding the first women's hospital in New York, and he's often called the father of modern gynecology. However, many of his notable medical contributions were a result of research he conducted on slaves without his subjects' consent, and often without anesthesia. So this statue that is on the right is a statue that actually stood of him in Central Park for many, many years, and it was right across from the hospitals. And it actually was torn down in 2018 after many protests because of his controversial and troubled past. The Women's Hospital opened in 1855, and During the first several years of operation, Sims performed over 55 artificial insemination procedures on 6 different women. Now, only one of these resulted in a pregnancy, so he had less than, I think they said, a 4% success rate. And the lack of success can be attributed to the fact that he believed ovulation occurred during menstruation. And I found this article in The Atlantic called "The First Artificial Insemination Was an Ethical Nightmare." And let me tell you, it was. So the first artificial insemination to result in a live birth was performed by William Pancoast. It was in 1884, and a 31-year-old patient came to see Pancoast about her inability to conceive. They initially thought it was a woman with her health and her fertility, but after performing many tests, they realized that it must have been a problem with her husband's fertility. Now, he was about 10 years older than her, and they performed tests on him and found that he was in good health, other than the fact that he had had gonorrhea several years earlier. After additional tests, because they thought he would be able to conceive, they found that his seminal ducts were completely blocked, so he would not be able to conceive a child with his wife. But Dr. Pancoast did not tell the couple that the husband's seminal ducts were completely obstructed. Instead, Pancoast scheduled another examination for the patient, and in front of a room of medical students, he knocked out the patient using chloroform, inseminated her, and now the source of the semen was obviously not her husband, and it was actually the most attractive medical student in the room was selected to be the source of the sperm. And the woman was never told about this. It was only came to light after her death. So next, I kind of wanted to get into some of the ways that law dealt with artificial insemination. So artificial insemination is legally defined in 2 ways. There's homologous insemination, AIH, which is the insemination of a married woman with semen from her husband. Or there's heterologous or donor insemination, AID, which is insemination of a woman with semen of a donor not married to her. Artificial insemination in the law. Although artificial insemination in humans was possible by the late 19th, early 20th centuries, it was not morally or socially acceptable. The women that underwent the procedure were often considered to have committed adultery, and then their children were not perceived as legitimate. In fact, in 1956, the Appellate Court of Illinois held that the use of artificial insemination by donor constituted adultery, even when the husband had consented, and that the child born by a result of this process was illegitimate. And that was in Dornbos v. Dornbos. And I was shocked that that was as late as 1956. And it wasn't until the 1960s that states such as Georgia and California began to recognize donor-conceived children as legitimate. And in 1967, Oklahoma actually became the first legislature to take a definite stance on the question of artificial insemination and passed a statute authorizing the use of AID. So the UPA was passed in 1973 and recognized the paternity of husbands who consented to their wives' artificial insemination. The UPA addressed artificial insemination exclusively in the context of married couples. And by 1998, 30 states had adopted the UPA or a similar statute. Now, the relevant section of the UPA, Section 5, which is addressing artificial insemination, states that the husband, rather than the sperm donor, is legally recognized as the natural father of a child conceived through artificial insemination, so long as 3 conditions are met. The artificial insemination was conducted under a physician's supervision, the husband gave his written consent, and the physician filed the consent with the state health department. So ultimately, the UPA applied only to children conceived through artificial insemination performed by a licensed physician on married women. Now, a movement started happening at the late 1960s, early 1970s, where artificial insemination was becoming demedicalized. So it began as this medical procedure because of its development by physicians and doctors. And then it remained this medical procedure for several decades because it met the needs of clients in society. But the insemination process can be very costly, and it often can take multiple tries. So it became very expensive for women to continue to see physicians for artificial insemination. And now the historians and different articles I read kind of chalked up this movement, the demedicalization of artificial insemination, to a few different movements. And one of them was the distrust of elites. And so the 1960s distrust of elites and the insistence on accountability and greater democratization led to challenges in all sorts of professions, but medicine took a particularly hard hit. And this kind of started the self-help movement, where people were trying to distinguish between procedures and responsibilities that called for specialized physician care and education, and those that the patients could be taught to take on themselves. Now, the second movement that really pushed for the demedicalization of artificial insemination was the women's movement. And this movement in the 1960s was feminism that focused on autonomy, empowerment, and once again, self-help. This was kind of a more assertive form of feminism, as people called, and it led to women's run clinics that were often run by not physicians, but lay women and women's organizations. And eventually, beginning in the 1970s, a movement in self-insemination started to challenge the necessity of insemination as a medical procedure. Although the number of women who have performed self-insemination can only be estimated, it is surely greater than those involved in surrogacy and in vitro fertilization and surrogate embryo transfer combined. So this led to the lesbian baby boom. I found this really fascinating article in the New York Times from 1989 that said, in a baby boom of unusual complexity, thousands of lesbians across the country are having children. So this was really the first time that large numbers of lesbians were choosing to have children through artificial insemination, as reported by gay and lesbian groups. So many of these women have been prevented from fostering or adopting and are finally being given the opportunity to choose to have their own babies. In 1989, about 40% of the women inseminated at the sperm bank in Northern California said that they were lesbians. And this was twice as many as when the sperm bank first opened in 1982. But I think it's important to note that many lesbian women who were using artificial insemination performed the procedure themselves. Now, I found that it was somewhat difficult to find research on the lesbian baby boom. There were only 2 articles that used this term that were published in 1989 and 1997, and that was from the New York Times and the Chicago Tribune. But new studies are starting to come out that are focusing on the aftermath and the social science of the lesbian baby boom. So as a part of the lesbian baby boom, these women's health organizations started publishing these self-help guides on how to artificially inseminate. So the one on the right I found online and actually read in its entirety. And both of these were published in the late 70s. The one on the right was published in 1979 by the Lesbian Health Information Project from the San Francisco Women's Center. And both of these just cost $2 at any radical bookstore, which I thought was awesome. Next, I want to look at some of the legal issues and consequences that resulted from the lesbian baby boom. First, there was this issue with adoption. In 1989, state laws recognized only the biological mother as a parent and did not allow her lesbian partner to adopt the baby. So as a result, if the lesbian couple were to break up, or the child's biological mother were to die, her partner could lose custody. Now, a completely different issue that caused many of the legal problems in the lesbian baby boom was whether or not to choose an anonymous or known sperm donor. When using a known donor, there was always this risk that the male donor may later want to assert rights to the child. But with an anonymous sperm donor, there's this starting premise on all sides that there'll be no contact and no role played by the biological father at all. In the era before AIDS, the donors were most often known donors, often male friends and sympathizers. And sometimes the donor would actually agree to play a continuing father role, and others would agree to stay out of the picture. Because many women didn't want a future relationship with the donor or a relationship for their child with the donor, liaisons or go-betweens were often used. But the AIDS epidemic really changed all of that because it introduced an element of risk to any insemination using fresh semen. So it greatly increased the importance of sperm banks, even in non-medical at-home insemination. So this is actually a page from the Artificial Insemination, an Alternate Conception for the Lesbian and Gay Community. And this is a page out of it that kind of highlights the important legal questions that the donor should be asking. I wanted to highlight the second bullet down that asks, what are my rights concerning the knowledge of the to-be-born child? And this was what they highlighted as a really important discussion for anyone that's entering artificial insemination and planning to conceive a child. And this leads into a few different case studies that I found. We'll see how much time I have and if I'll be able to get to all of them. So first is Robin and Russo, and this case was Thomas S. v. Robin Y., and it happened in New York. So Robin Young and Sandra Russo met in 1979, and they've been in exclusive and committed relationships to this day. Early on in their relationship, they decided that they wanted to have children. So Russo, the older of them, planned to have a child first, and they enlisted the help of a gay man, Jack. Russo, Robin, and Jack agreed that Robin and Russo would raise the child as co-parents and that Jack would have no parental rights or obligations. But they also agreed that Jack would make himself known to the child if the child ever made an inquiry about their biological origins. Robin and Russo asked Jack to make himself known to the child at a future time because they feared that the child might suffer emotional pain if they did not know the identity of their father. Shortly after this, Cade, their first child, was born May 18th, 1980, as a result of Russo's artificial insemination. Now, shortly after Cade's birth, Russo and Robin decided that Robin should have a child. They enlisted the help of another gay man, Thomas. They met with him at his office, and they reached the same agreement that they had reached with Jack. So Thomas agreed that the child born of the artificial insemination would be raised by Russo and Robin as co-parents and as Cade's sister. Additionally, the petitioner would have no parental rights or obligations, and he would only make himself known to the child if the child asked about her biological origins. Now, here is the trailer for the HBO documentary Nuclear Family, which actually highlighted this case. So I'm going to play a quick clip from that for you. It looks like Zoom won't let me play the video for you and screen record at the same time, or I'm having technical difficulties. So I'm going to put the link below and you can watch this at your leisure. So after Rye was born, November 16th, 1981, there was no contact between her and Thomas until 1985. In early 1985, Cade, who was almost 5 years old, began to ask about her biological origins. Robin and Russo contacted Jack and Thomas, the men who helped make them, as they referred to them with the girls, and asked whether the men would meet the children. They agreed. So the whole family, Robin Russo and the children, traveled to San Francisco for the meeting. They spent time together in San Francisco, rented a beach house, and this led to a continuing relationship between the girls and the men. Between 1985 and 1991, Thomas visited with the family several times a year. They exchanged postcards and letters, but all of the contact was at the discretion of Robin and Russo. But in late 1990 or early 1991, Thomas insisted on going on vacation with Rye outside of the mother's presence. He wanted to introduce Rye to his biological family and was not comfortable including Robin and Russo in that process. And when Robin and Russo refused, he commenced proceedings for paternity. So the trial court and the appellate court had very different views on the family that Robin and Russo had formed. The trial court held that the father was equitably estopped from obtaining a declaration of paternity. The court found that Tom's conduct, including his failure to provide financial support, his failure to file for paternity earlier in Rye's life, his lack of effort to see Rye, confirmed his earliest representations that he did not intend to be a father. The court also concluded that an order of paternity would not be in the best interest for Rye. According to the court, to Rye, Thomas is an outsider, attacking her family, refusing to give it respect, and seeking to force her to spend time with him. But on appeal, the appellate division completely reversed. The appellate division saw a very different family than the one seen by the trial court. The appellate division saw Tom, Robin, and Rye as a family no different from that which exists when parents divorce and the mother remarries. The appellate majority considered the trial court's decision a termination of Tom's parental rights and found that Robin was the one who was stopped because she initiated and fostered a relationship between Rye and Tom for those years. The court held that Thomas was entitled to paternal rights. Now I want to highlight a few things in the changing legal landscape. To regulate artificial insemination, many states have statutes that protect the sperm donor from the obligations of parenthood and also protect the donee from the donor's assertion of rights of parenthood. So these statutes typically extinguish all rights and obligations of parenthood in the donor and then vest all of those rights in the donee's partner. Now, these statutes apply to donors that are anonymous, sperm bank donors, from claiming parental rights on children. But these are not in place if you use a known sperm donor or a friend. A recent article stated that the donor could definitely fight for custody, which could be a huge, expensive legal battle in the end. So they explained that you could save money on sperm up front by using a friend, but it could be quite expensive down the road if that friend decides to sue for paternity. Additionally, insurance coverage is generally not available to lesbians to cover AI procedures. The state insurance regulations allow insurers to provide coverage only in the case of medical infertility, and that is measured by standards only applicable to heterosexual women. We talked about artificial insemination at home throughout the 70s, 80s, and 90s, but I want to talk about artificial insemination at home today. The main reason that people participate in at-home artificial insemination is to save money. An in-office artificial insemination cycle can cost between $300 and $600. And these artificial inseminations have a success rate of only 20% per attempt. So often multiple attempts are required. So the cost of artificial insemination can add up really fast when you add up the cost of purchasing the sperm, the cost of the procedure, the cost of storage. So that is why many women are turning to at-home artificial insemination. If you Google at-home artificial insemination, you will be able to find kits that you can order. You'll be able to find at-home guides. You'll be able to find YouTube videos of people explaining their experience. So when people ask, do turkey baster babies really happen? The answer is yes. Artificial insemination at home is very real. Now, I wanted to talk about how artificial insemination has allowed us to reimagine modern families. By 1997, the highest courts in New York, Vermont, and Massachusetts had allowed second parent adoptions. So this means that a non-biological mother is legally able to adopt a baby while the biological mother retains rights. Also, the updated version of the Uniform Parenting Act of 2017 fully protects both married and unmarried same-sex couples. It also includes many important provisions protecting parents using at-home insemination and gives access to a free system to establish parental rights available at every hospital in states that adopt the UPA. As of September 2021, California, Vermont, Washington, Rhode Island, Maine, Connecticut have adopted the 2017 UPA. And although there's been a lot of legal progress, there are still risks when it comes to using a known donor and having them assert rights. The risks that lesbian families and heterosexual single mothers face encourage them often to completely exclude donors from playing any role whatsoever in their family. Now, this may mean that the child and the family must forego certain relationships that could be complementary and supportive of the core unit. This is actually discussed in the Nuclear Family documentary, and it talks about the tension between both parties, the lesbian couple and the gay man, at the want to construct a progressive, non-traditional family, and the idea of having this nuclear family that is traditional and contained. So that's something I really want to focus on in my paper, is the tension of reimagining families and the tension of nuclear families. So I had a couple of questions for you before I wrap up as I work on my paper. I wanted to know if I needed to include more case studies in my paper. I found a few other case studies, including a lesbian couple that used anonymous donor for artificial insemination and their successful process without any legal battles. So I'm going to highlight that on the following slide if you want to read about it, because I do have a slide for it. We just didn't have time to get to it today. And then another question I had as I prepare and work on my paper is I have a few potential leads on interviews with women and couples that have used artificial insemination. Do you think this would enhance the paper if I had some firsthand stories from different women that have tried this process? And then, is there too much focus on the history and development of AI? Would you rather hear more about modern day AI than historical AI? Thank you so much for watching. I look forward to hearing your comments and getting your feedback below. I'm going to highlight that other case study real quick at the end, and I hope you have a great day. Thank you. So the last case study that I wanted to highlight really quickly was Lori and Janet, who used Fenway Health in Boston. So Fenway Health in Boston was founded in 1971 and believes that healthcare is a right, not a privilege. So Fenway centers on LGBTQIA people and people of color and other undeserved communities to deliver accessible healthcare, supportive services, and transformative research and education. So in 1983, they founded the Alternative Insemination Program, and it was the first in the country. Since its inception, over 1,000 babies have been conceived through Fenway's Alternative Insemination Program. Now, while artificial insemination is a common route used today for LGBTQIA+ couples looking to start a family, 40 years ago, it was a very revolutionary concept. And in 1985, the first baby at the Alternative Insemination Program was born to Lori and Janet. Now, they didn't encounter as many of the same legal battles as were encountered by Robin and Russo, and this is mainly because they used an anonymous donor. And sperm banks weren't initially available to lesbian and single women, but when they started to become available to lesbian and single women, this really opened up doors and took down a lot of those legal barriers that women had been worried about. So this is kind of a contrasting case study to the Robin and Russo case study to kind of highlight the different outcomes, results that happen when you use a known donor versus an anonymous donor. So let me know if you think that this is something that would really enhance the paper or something that you feel like you missed out on during my presentation. Thanks again for watching.